I'm Las Vegas personal injury attorney Neil Schaus. Normally, when an accident victim sues for negligence here in Nevada, the plaintiff has to prove that the defendant violated his or her duty of care to the plaintiff. But if the plaintiff sues the defendant for negligence per se, the court will presume that the defendant violated this duty of care. Instead, the plaintiff just has to show that the defendant broke a law that was meant to protect people like the plaintiff. A common example of negligence per se is a car accident in which a plaintiff was injured by a defendant who was driving under the influence of alcohol. Because the purpose of DUI laws is to protect other people on the street, such as the plaintiff, the court will presume that the defendant breached his or her duty of care simply by driving drunk. A plaintiff must prove the following four elements in order to establish a negligence per se here in Nevada. 1. There is a law or statute that exists to protect a class of people. 2. The plaintiff was a member of this class. 3. The defendant violated the law or statute. And 4. The defendant's violation of law caused the plaintiff's injuries or damages. If you've been injured in an accident here in Nevada, call my legal team at 702 Defense for a free consultation. Our attorneys here at Las Vegas Defense Group are ready to fight for the highest money settlement in your case.